Chief Justice Earl Warren of the Supreme Court once said that when he read the newspaper, he read the sports page first, because that chronicled man's triumphs, and then the front page second, because that headlined man's failures. Here today on the Culture of Sports, we have Mike Phillips, a partner with the law firm of McGuireWoods in the Labor and Employment Department. He's going to talk about the role of lawyers in the culture of sports. So, Mr. Phillips, thank you for joining us today.
Thank you for having me, Jonathan.
So it's a good thing or a bad thing that lawyers are becoming more and more involved in sports?
Well, I don't know if it's good or bad, but I think it is, as you can kind of see by the background of the commissioners of the major sports leagues. Being a lawyer is a major advantage in running a professional sports league these days.
Now, I was talking to a friend of mine who coaches baseball, and with Bryce Harper up, Machado up, I said, is there ever a limit to, how much a player can make? I mean, it looks like they're going to be going in the $40 or $50 million range. And he said, no, the lawyers have done too good a work on their labor deal. So what sort of work have the lawyers done in baseball?
Well, I think that's true. I mean, I think what the lawyers have done in baseball is set up a system where players are capped, where they're limited in what they can earn in the first few years in the league. Then you've got years of arbitration. Then you've got years where the sky is supposed to be the limit. But what we saw this offseason is that market forces are always at play, no matter what the collective bargaining agreement says.
And so is it working? I mean, since salaries are rising, does that show that the lawyers are doing their job and sports is working?
I think you could say that sports is working, but I think you could always say there's always going to be challenges.
And so what do you see as the challenges ahead?
In baseball specifically, probably the biggest challenge is the one we just mentioned, which is that you have a collective bargaining agreement that runs through 2021, and you have expectations about how that's supposed to function. And the market now is rearing up its ugly head and saying that ownership is not willing to pay an unlimited amount for a 31-year-old or a 29-year-old free agent. And how do the players, it's more a player's problem right now than an owner's problem, but how do the players respond to that? And what are the implications for the next collective bargaining agreement?
And so as a Cubs fan, what do you think that they have done better within that framework than my Baltimore Orioles?
Well, I mean, I don't want to disparage the Orioles in any way.
Everyone else does. Well, you'd be the first on the show now, too.
But the Cubs were sort of at the leading edge, I think, of an understanding that the best value that you can get comes out of a player who you're paying a rookie salary or something close to a rookie salary. And they've also come to the understanding that these days athletes in all sports, baseball included, are much more experienced, much better prepared as 21, 22, 23-year-olds than they were a decade ago or 2 decades ago. So they've really been able to leverage that value of players like Chris Bryant, Kyle Hendricks, who are making or were making close to the minimum salary.
No need to bring up Jake Arrieta, that's for sure. So here in Maryland, this is Big Ten country. So what do you see the major issues in college sports?
Well, college sports, I think, in particular, the major issue is going to be compensation.
So where do we stand on that now? What are going on with the cases? You had Brown case and others?
Sure. Well, there's 2 cases out there right now that are pending that are going to be very important. One is the Jenkins case, which is led by the former agent Jeffrey Kessler, who's leading a group of plaintiffs' lawyers that are really trying to blow up the entire structure of college sports and really make it into a market system. The other is the...
and what's the status of the Kessler case right now?
The Jenkins case, the Kessler case, is gotten past summary judgment, which means it's going to go to trial. And unless there's some intervention by a judge, a jury is going to decide the issues that are raised in that case.
Okay, and the others?
There's another case up on appeal at the Second Circuit, the Lamar Dawson case. And the Lamar Dawson case is attacking the compensation system, the amateur system of college sports, but from a different angle. The angle of the Dawson case is that athletes are employees, college athletes are employees, and consequently they need to be paid the way that employees are paid, with overtime, minimum wage, and so forth. It's not a theory that's been successful so far, but the Ninth Circuit Court of Appeals, which, as you may know, is the most liberal court in the country, most liberal appellate court in the country, is going to decide these issues, and an adverse ruling for the NCAA could have significant consequences.
Now, if you were counsel to the NCAA and there was an adverse ruling, what would you tell them to do?
Well, I mean, there's a number of solutions, I think, for the NCAA if there were an adverse ruling. One, of course, is to fight. One is to seek a legislative solution, which many professional sports leagues have done as sort of to solve some of their labor problems. And the third is a settlement, which would involve, I would believe, some sort of voluntary compensation system.
Now, do the courts look at sort of the real world where, as of now, of the 130 FBS schools, 104 lose money? Will they look at it and say, how are they supposed to be able to pay the players now when they're already losing money?
Right. Well, they do. And you know, the one rule that you see running through all the cases about both professional and college sports is that sports is different. The courts treat sports differently than they treat any other industry. You can see that even in the Northwestern case. At the NLRB, you can see that throughout the case law. So courts do consider the real world. They do consider the fact that college sports are unique. They do consider the value of amateurism, and how that plays into these pending cases is something that remains to be seen.
Now, what led you into labor law with a sports specialization? You were Phi Beta Kappa law review. You could have done whatever you wanted.
Well, certainly. And it's really an intersection of two things, which is one is my area of expertise, which is labor and employment, and two is my interest, which is in sports. And over the years, I've had the privilege to represent professional athletes and others involved in the professional sports industry. And sports creates a unique set of challenges and a unique set of applications of labor law, which is really a body of law that's really designed for the industrial worker. And but in sports, you have labor unions pervading the landscape. You have collective bargaining agreements, just like you do in an industrial setting, and you have laws and rules that have to be applied to that, but are usually applied somewhat differently. And that's what makes it, I think, such an interesting intersection of the industry with the legal field.
And do you consider that labor law has evolved to adequately handle the sports world?
It has and it hasn't, all right? I think that there are a lot of situations that come up in the sports world that are an artifact of labor law. For instance, why does a player get suspended for half a season for taking a performance-enhancing drug, but if the player beats up his wife, he only gets suspended for 3 or 4 games? Well, the answer to a lot of those questions that sort of mystify fans and the media is the way that the collective bargaining agreements operate. And you have, in that case, a regime of drug testing that's been agreed to by the union, and penalties that are fixed in a collective bargaining agreement, and a second regime for other types of discipline that has not been agreed to. And that's why you see sort of these disparities in treatment of what seem to be very similar or more severe type of conduct. And so a lot of those mysteries, can be related to sort of the vagaries of labor law and the vagaries of collective bargaining.
Well, let's take a look at college sports for just a second here. So if they are considered to be employees, does that mean if they don't start, they can be fired?
Well, sure. So it depends whether they're employees or it depends whether they're unionized employees, because there's a difference. A unionized employee can be fired only for cause.
Would not starting, would that be considered cause? Because you could say, how is he performing? How is he fulfilling the roles of the contract?
Well, right, and that's probably a body of law that would need to be developed. But usually, cause, means that you've committed some kind of policy or rule violation in a labor context. But a non-unionized employee who's not protected by a collective bargaining agreement is at will. They're at-will employees in every state in the union.
And so what about, how does this comport with immigration laws? How can somebody come here on a student visa to play basketball for, say, the University of Maryland, but then all of a sudden become an employee? Is that a clash?
Sure. I mean, that's another area of the law that would have to be adjusted if students were being paid and treated as employees, because, as you mentioned, most student athletes are here on student visas, but an employment visa is a much different animal. An employment visa requires the employer to show, in many cases, that there are not sufficient local labor force to perform the job, that the player has unique skills.
And how would you prove that if the foreign player was sitting on the bench?
Exactly. And for every foreign player who comes to play college basketball, there's probably 10 American players who would say they're as good or better, or they would like to have that scholarship that the foreign player is taking up.
And so how does this all comport with Title IX? Which is, I mean, in college sports, football provides 70% of the revenues. So say you're a field hockey player, can you say we should be, because of Title IX, we should pay the exact same amount as a starting quarterback?
Exactly. Well, that's one of many open questions about how to compensate college athletes. But how would you do it in a way that complies with Title IX, that fulfills the equality standard that Title IX imposes? And would you pay every player, regardless of sport, a fixed stipend? Would you pay players according to their performance? Would you pay them according to seniority? Would you pay them according to whether they generate revenue for the school or they don't? And those are questions that remain open. Those are questions I think that are very troubling to many people in college sports.
Now, at the Aspen Institute for Sports last week, they were talking about players now going after sponsorship dollars. So you seem to think that, there's just this pot of money that's going to go to college players. So how would that work under employment law, that if you could go out and get sponsorship? Suppose a teenage basketball player gets a sponsorship, and as he's going out there, he's in a car accident. Who covers that?
Well, that's a good question. I mean, sponsorships work a little bit differently. So employment usually is based upon control. And so you look at...
How do you define control?
And control is usually control over hours, control over terms and conditions of employment. And you'd look at how much control the sponsor has over the athlete. And if a sponsor had sufficient control, they could be considered to be an employer of an athlete.
Now, the University of Wyoming, they had a study commission that showed that their football team benefited from $46 million in branding from all its marketing activities. So the football players at the University of Wyoming, they're going to have a huge appeal to a sponsorship. The field hockey players, the women's tennis team, not so much. So do you see that as a huge labor issue where they can say, hey, we're not getting the same sponsorship amount as we should under Title IX because you're spending all your money pumping the football players and not promoting the field hockey team?
Right, it could be. It goes back to that issue of equity between college athletes, and how do you create a system that's equitable for non-revenue sports as well as revenue sports.
And so what do you see as the big issues coming up now with the Ninth Circuit, with their rulings coming up now? Do you see the NCAA as just facing a very litigious future? Or
I think that's probably right. I think that they may be able to dodge a bullet in the Dawson case if they get a good ruling from the Ninth Circuit. I think if they do, the issue of overtime minimum wage as a way of attacking amateurism is probably going to be dead, at least for a while. But you still have other approaches, like in the Jenkins lawsuit. And I think that what the NCAA probably faces is a future of attacks, both legal attacks and attacks from the media and public relations attacks on the amateurism system.
so as one of the leading experts in the field, what would you counsel athletic directors to do?
Well, it's a very tough issue. What I see in the landscape is this, is that when you have the confluence of media opinion, public opinion, and then you have plaintiffs' lawyers or the legal community that sees this as an area for attack, it's a matter of time, right? You have some time where you can maintain the status quo, but the status quo is not going to hold forever. So it's probably time, in my opinion, for colleges, universities, athletic directors to start thinking about what the future of amateur sports is going to look like.
And so how should they prepare?
Well, I would, as I mentioned before, I think that probably the best solutions for college sports are either a legislative solution or some type of voluntary compensation system, perhaps combined with a legislative solution or combined with a global settlement of one of these lawsuits. But it would be a way, I believe, of instituting a system that has elements of equity, that preserves competitive balance, that preserves to some extent the spirit of amateurism, as opposed to sort of the jungle free market
Yes.
that the Kessler plaintiffs would would like to impose.
Now, shifting gears just a little, there's not just league lawsuits going on in college sports, it's going on in minor league sports too,
Yes.
particularly for baseball and for hockey. How do you see those proceeding?
Well, the minor leagues just got an exemption in the latest tax bill and I haven't read it thoroughly, but I believe it insulates them from the kind of wage and hour claims that you're seeing addressed to college sports. I don't believe the hockey minor leagues have the same protections. And so you're seeing the same attacks on the minor leagues as you are on college sports, which is essentially that from a minimum wage and overtime perspective, minor league athletes are not being treated the same way as other workers and other employees.
And how come their lawsuits don't get the same attention that the college ones have?
Well, that's an interesting question, and I think it's because they're professionals. Because they're viewed as being less vulnerable than college students. They're a little bit older. But the truth of the matter is in baseball and hockey as well, you have players who are entering the minor league system in their late teens and really have some of the same issues and motivations as college athletes.
Now, in terms of hockey, when you saw the fifth-string goalie go in for the Blackhawks in the playoffs, what were you thinking? Were you thinking, boy, I wish I was his agent looking at his employment contract right now?
I was shocked. I had no idea. Did you have any idea that
I didn't know
that they kept rosters of local people?
I did not know that things like that could happen. You could literally pull off a 36-year-old certified public accountant and put it in there. So what was that like at work the next day when you guys realized that and it worked out well?
Well, to me, I thought it was more like a movie than real life. But I think there's probably a lot of people lining up now to be the fifth-string goalie for the Blackhawks.
So when I was working in sports, I am a lawyer, and they asked me to look at contracts. I was stunned at the contracts. They basically had the team assuming all the liability and stuff. Have any of these schools or teams come up to you and say, could you just take a look at our contracts and make sure that they're in order, that we're protected? Because what I'm talking about, these contracts were drafted by the groundskeeper for the things, and they had the team, and I'm not going to say what the team was, but it was considered one of the best managed sports organizations that were taking complete liability. Has any school, any team ever had the wisdom, the foresight to come up and say, will you take a look at our complete legal structure to make sure that we're in compliance?
No, I mean, I haven't, at least in terms of the colleges, universities that we've represented.
And what would be the first thing you tell them to do? Say the athletic director from a Big Ten school comes up and says, we're worried about these cases, we've seen your interviews, we've read your articles, what do you recommend we do?
I think it's difficult for an individual school or an individual university to protect itself against these kind of things. And it's really not the minimum wage piece of it and the antitrust piece of it are not really issues that you can protect by contract. I think that the way that schools and universities can protect themselves is through some sort of collective action, legislative solutions, but working together to try to resolve this compensation issue that I, at least in my opinion, is not going to go away.
And can you point to any of the clients you've had to them as example that you can talk about publicly within attorney-client privilege?
Yeah, well, we can't talk publicly about what our clients do, but what we can talk about is the overall landscape of college sports and the fact that change in the way that amateur athletes are treated seems to be certainly on the horizon, if not inevitable.
And in your overall practice, how has employment law changed?
Well, employment law has changed quite a bit. And employment law has changed in a number of ways, but one of which is an increased focus on class and collective lawsuits and employers' tactics to avoid class and collective type of lawsuits.
What exactly does that entail?
In other words, class and collective lawsuits, meaning instead of an employer suing over their wages or their compensation, it would be a group of employees suing, or an industry-wide practice that comes under attack bit by bit by groups of employees. So we've seen an increasing amount of that activity. And
do you consider that be for the good or the bad of the culture of sports?
Well, I mean, you can see it's starting to seep into the culture of sports. The Jenkins case, the Dawson case, the Berger case, which was another similar lawsuit that preceded it, all sort of arise out of that atmosphere of lawyers looking for targets for wage and hour and other types of employment litigation. So what you've seen in amateur sports is sort of an outgrowth of the overall trend.
And so how do the concussion lawsuits and the injury lawsuits play into this?
Play into the compensation issue?
Yes.
Well, I mean, the concussion lawsuits are, a slightly different animal, because those are really lawsuits that allege a failure of sports leagues to protect players and protect player safety. So it's, we've seen them in college sports. I think we'll continue to see them in college sports, but it's a whole different set of liabilities for colleges and universities.
So as one of the leading lawyers and a father of daughters, do you ever sort of look and say, hey, the highest concussion rates are for, female hockey and female soccer too? I mean, does that ever sort of catch your eye?
Well, and I think that's probably true. I'm not sure, but that may be true also of ACL injuries and other types of injuries. But as a parent, do you prevent kids from playing sports? Probably not, right? Do you prevent them from playing high-risk sports? Maybe. And I think that's where, you're seeing some impact of these on youth sports.
Now, Title IX has had a huge impact on sports. Has it had much of an impact on your practice?
Title IX has had some impact, but where it's impacting our practice and impacting colleges and universities has nothing to do with sports, to get off topic a little bit, but
Sure.
it has to do with sexual assault on campus and Title IX procedures that are required to essentially prosecute those kind of events on campus.
Do you see the universities improving in that regard?
Yes, I mean certainly the universities are improving. Certainly, there's been more awareness at the college and university level of both of the need to address incidents and also of the procedural protections that are necessary both for the accuser and the accused. But it's been, I think, a bit of a difficult process for colleges and universities to try to get processes in place.
And so is there one thing that you have seen that just amazes you that, you would scream out to, clients and potential clients, you need to do this to protect yourself?
Well, in the Title IX context?
Yes.
Well, yeah, I think in the Title IX context, things that have been surprising are, number one, the lack of understanding of procedural protections sometimes.
And what do you mean by that?
In other words, that how do you have a hearing? How do you have a process that respects the rights of both the accuser and the accused? And what you've seen sometimes from colleges and universities is processes that are one-sided one way or another. In other words, that either try to sweep things under the rug on one hand, or on the other hand, don't give the accused the procedural protections they would in court and in a due process setting.
And would that eventually come out?
Come out meaning?
Well, if I'm at a school with Title IX violations and I think, if we sweep it away, it's not going to come out. Eventually, as I've always, I'm a lawyer, counsel my friend, you're going to get caught, is what I tell them. Is that true in the Title IX?
And that's true in any context. It always comes out. You have to make that assumption.
And do you tell your clients that? What do they say when you point that out to them?
Well, it's it depends. There's sometimes some denial. There's sometimes how am I going to get caught? And my response is, it doesn't matter how.
And what do they say to that?
Well, you hope that it comes to some sort of awareness and a need to deal with the problem.
And do you think from what you've seen, it's because they don't want to deal with the problem or because they just don't appreciate it? Because, if they're president of a university, probably they're not a lawyer. They moved up in academia,
Sure.
They were head of their department, then they became a provost, then they became president. If they're an athletic director, more than likely they played football or basketball and moved their way up through the system. So do you think it's sort of just a lack of appreciation?
I think some of it's that, some of it is just an inability to deal with the difficulties of these kind of incidents, and the position it puts the athletic department, the coaches, and everybody else associated with the program, as well as the athletes.
Now, you and I met because I so admired some of your articles I came across online. Had any others from the sports world approached you that way like I did?
You're the only one, Jonathan.
And so what would you advise them in terms of reading these things now?
Well,
to look for?
I think that anybody who is involved with college sports should be paying attention to the cases that are pending, especially the two I mentioned right now, but also the overall legal landscape. And change is much easier when it can be managed, and change is very difficult when it's imposed by a court or a legislator or Congress. And I think that there's an opportunity right now in college sports to be able to manage some of the change that is probably coming in the next 5 to 10 years, but it needs to be managed. It requires some attention to how the legal landscape's changing.
And so with the new world of sports featuring esports and other things, what do you see some of the employment issues with that, with the gaming and ones?
Well, yeah, that's a very interesting area, and something I'm just starting to become aware of and get into. But there's employment issues involved in any field, and it's really becomes an issue of control, and to what extent are gamers, for instance, who participate in esports, who are they working for, and who's benefiting from their labor.
Well, I look forward to reading your articles on that, and I highly recommend the others do too.
Thank
This is
you.
Jonathan Yates, thanking you for joining us with Culture of Sports again.